be on top again. I'm not gonna let you take me down. It's gonna be the whole 9 yards or nothing.
Hi, I'm Tom Mealy. Welcome to Legal Straight Talk.
I'm Brett Harrison, and today we have a special guest, one of the associates in the Harrison Law Group, Effie Cho. Welcome to the show, Effie. I'm glad to have you.
Hi, I'm happy to be
You
here.
know, today, and first of all, I want to thank everybody for tuning in last week and watching as Brett and I discussed the issues of criminal law, which, you know, I got to tell you, Brett, we have so much that we're just, you know, kind of skimming the surface with that. And it's going to come to a point where we're going to continue and we went into misdemeanors and drinking and driving, but eventually we're going to get into the criminal aspect and go up even as far as murder, murder in the first degree, et cetera, et cetera. There's so much that we have to cover.
Just remember, the difference between murder and attempted murder is bad aim and one more witness.
Yes, this is true.
I'm just kidding.
But today, Brett, is a little different. We're gonna bounce back now more into the issues of
in a civil case,
personal injury, civil actions, and we're going to talk with Effie about depositions. Everybody knows that a deposition is a crucial part of any case. So explain to the audience what a deposition is, and then we'll talk to Effie and find out why it's so crucial to either prep for these type of things.
Right. What happens is, as you have a personal injury case, and once you do a summons and complaint where you're suing the other side and it's now in court, and they put in an answer and you put in your responses back and forth, and both sides, the plaintiff and the defendant, and the two different attorneys for the plaintiff and the defense attorneys exchange documents. Eventually comes a time when we get to depose or ask the defending questions, and they get to ask us the plaintiff questions, our plaintiff.
All right, I want to back up because I want to make sure that people clearly understand the terminology we're using. Remember, the lawyer, non-lawyer kind of thing that we built this show on.
We're going to say you're the plaintiff. We're representing you in a car accident.
You sure don't want to be the defendant this time?
No, we're going to make you the good guy.
All right. Plaintiffs, defendants, explain to us, first of all, who is a plaintiff?
Okay. The first person on the summons and complaint, the person that's suing
the individual.
Okay. The individual, for example, let's say, Tom, you were stopped at a red light, and what happened is another person popped you in the rear. And as a result, Tom, you were injured. So in this case, you'd be the plaintiff, and the person that hit you and who owned the car and who was driving the car would be the defendant or defendants.
Right.
Okay, so now in this case, let's say we started a summons and complaint, we sued them and said, basically, on this date and in this county, I was driving a car on X, Y, and Z road, and as a result of contact between the cars, I was injured. Okay.
Right. Well, that's the summons and complaint.
And now you would put in an answer, and
let's slow down for me because I want to make sure people understand something. Effie, when we do a summons and complaint, explain what is in that complaint. Explain what a summons and complaint is and why we do it.
So what a summons and complaint is, it's the actual document that you have to file with the court to start your legal action. So what has to go into the complaint are the allegations that you need to allege against the defendant. So for example, if you're involved in a motor vehicle accident, you have to make certain allegations against the defendant. There are certain things you need to allege contact between your vehicle and the defendant's vehicle. You have to allege who the owner and the operator of that vehicle is to make sure that you have the right person. You have to also allege, there are different causes of actions. You have your own personal cause of action as the injured party. If you're married, if you have a spouse, and you're injured at the time of the car accident, your spouse has what's called a loss of consortium claim. So what that includes is loss of services. So let's say that when you're injured, your spouse has to do more work around the house because you can't. You're hurt, you're sick, so you're bedridden. So your spouse has to pick up most of the slack at home while you're recuperating. So that person, the spouse, has a loss of services or loss of consortium claim. So
also in the loss of consortium would also include sexual relations with your spouse.
Exactly, that is also included.
Well, let me ask you a question, Effie. So in this summons and complaint, now once you compile all this information into the summons and complaint, in the summons and complaint, you're going to ask in the complaint for a so-called dollar figure for damages, correct?
You actually don't put the dollar figure in the summons and complaint in a personal injury action.
Well, years ago, I don't know if you knew this, we used to do that.
Right.
We used to sue for $5 million, $10 million.
Yes.
We don't do that anymore.
Yes.
So what do we put in that complaint?
So that's what's called the addendum clause, and those do not go in personal injury S&Cs anymore. They actually go in the bill of particulars, which
Which we're going to get into in a second.
Yeah.
Okay.
Yeah.
So how do they list, if you're doing a summons and complaint and you're talking about these issues, you have to put in the complaint what you are looking to recover as a result of the damages. So how do we specify it now in the complaint?
you don't put in the dollar figure, but you put in the damages that you suffered. You put in the summons complaint that you're severely injured or seriously injured, and also that you've suffered damages to.
But I know that there's an issue in the summons and complaint where you have to specify that. So in the complaint, does it specify that the damage dollar amount supersedes the lower courts?
Correct.
Okay.
That's correct.
So
That's
that
correct.
in and of itself is telling me that is, anybody who knows about what the lower courts are, you know that the lower courts are usually $25,000 and under.
If you're in Long Island, it depends on which
Well,
county.
so we're
or
assuming Long
city,
Island.
but-
This is Long Island based. So you are, in essence, putting in there by specifying to supersede the lower courts, you're saying that the dollar value of your case is going to supersede hypothetically $25,000.
I mean, generally, I guess you can.
Well, what is the
infer
dollar
that.
value of the lower court? Because if somebody gets this summons and complaint in the mail, all right, and let's assume that a defendant gets this summons and complaint in the mail, they're going to read this summons and complaint. 9 times out of 10, Effie, they're going to call up and they're going to say, I'm being sued. So the language in that complaint, if you see something in the complaint that says that we are suing you in excess of the lower courts in Suffolk and Nassau County in the state of New York means anything under $25,000. Am I correct, Brett?
It depends on the court.
Yeah, I mean, certain
But
courts are
normally,
15, some are 15, some are 25.
District court,
depending-
yes.
right.
So that means that we are going for a
And an
dollar
amount
figure in excess
of course.
of that, which now brings you up to almost an unlimited amount of money, whether it's $1 million, $2 million, $10 million, or $100 million.
You still got to prove it.
You
but
have, yes, but that's what that means without putting it in there. So when they get a summons and complaint and they're served, whether it's a plaintiff or a defendant, in this particular case, the defendant is served, and they see that language in there, they now clearly understand, because they'll say, well, wait a minute, what are we suing for? I hate that word sue, by the way. You know that from our
Yep.
past show. What are we looking for compensation for? I always like to use the word compensation. I hate the word sue. So we are asking for X amount of dollars based on that summons and complaint. Now, we have a summons and complaint. The defendant, once you serve that on the defendant should do what with that complaint?
They should send the complaint to their insurance carrier.
Why?
Because the insurance carrier is the one that actually hires or retains the defense attorney to actually do the defense work.
That's what you pay your premiums for car
Exactly.
insurance.
So now they get this summons and complaint, they call up their carrier, they're saying we're being sued. They now have, the carrier has an obligation, Brett, under the provisions to hire counsel to
And
represent
to
them.
put in an answer and to defend them accordingly.
Now, let's get back to the answer. Effie, explain to me, they have 30 days in New York, am I correct?
It depends if you're served personally or if you're served by another means of service under the CPLR.
You serve,
So it's either
let's just
20
go with
days or 30
personally
days.
because it makes it easier.
Then it's 20
So now,
days.
I do something wrong, I get served by a process server, I get a complaint, summons and complaint that I am being so-called sued. I call my carrier gives that. they have to now put in, the carrier has to put in an answer to the law firm
Correct. Within 20 days.
based on the summons and complaint.
Correct.
All right, now, explain to me what an answer is.
The answer is actually, it's what it sounds like. You're basically answering the summons and complaint. If you take a look at the answer and you put it side to side next to a summons and complaint, you'll see that the defendant specifically answers each allegation contained in the summons and complaint. So the answer will either admit an allegation, deny an allegation, or something called a DKI, which just means that they're denying
Knowledge and information.
sufficient to form a belief. So it just means that they don't have enough information to either admit
Right,
or
they're waiting
deny.
for all the discovery to be fully complete.
Well, it's another thing, discovery down the
Right,
road.
right, and we'll talk about affirmative defense. Let's
Well, I got to keep the legal suit down a little bit, all right, because it keeps popping up. But
let's get to the preparation of now we have to now that
well, now
client is
after
gonna-
the answer comes in,
well, then we go into a whole bunch of discovery, and then eventually we're going to be at a point where
we're going to depose.
where we're going to ask their side questions, and they're going to ask our client questions. Now let's take it from the standpoint of we're prepping our client to be prepared to be deposed or ask questions from the other
By
side.
the defendant's
By the-
attorney.
Right.
So that side is actually going to come into that law firm, and that side has a right to question the plaintiff, in this particular case,
Correct.
as to what transpired. Effie, you do a lot of depositions. You prep a lot of people for depositions. Let's take an average car accident, hit in the rear type accident. How would you advise your client prior to that deposition? What would you advise them to
First
do?
off, what are your concerns?
Good point.
Why don't we start with the function of the deposition, your concerns, and then how you utilize your client, and you explain your concerns to the client.
So when I prep a client for a deposition, especially for a pop in the rear kind of case, those are fairly simple, but for a client who's never been in a deposition before, someone who's never been deposed before, they have no idea what a deposition is. The most important thing is to just prep the clients and give them an idea of the questions that they're going to be asked, and that I go through a step-by-step preparation with them. I ask them first, their preliminary information, background information first, because a lot of the times, such as their name, date of birth, last 4 digits of their social, where they live, how long they lived there for, who they lived there with. These are all background questions which the defense attorney is entitled to ask. And I have clients, they ask me, well, why do they need to know this? Why is this important to the case? I got hit. Why is this important? And I just explain to them that it's all relevant and they're entitled to this information because, as the plaintiff, you're putting your person into question. So you have to answer these questions as ordered by, the courts.
Another reason it becomes important is, let's say your name is John Lewis. You know how many John Lewises there are? So they want to know, where did you live for the past couple of years? Where did you live prior to that? And where did you live prior to that? Or do you go under any other names? Because they're going to do a background search
Without a doubt.
on you. See, are you involved in any motor vehicle prior accidents? Because all accidents that are where the police come, they're recorded and put down in a
So a deposition is not necessarily, and a lot of people have to understand, a deposition is kind of in a way of isolating the truth, what is and what isn't. We had a case one time where there was multiple aliases that came up on an index check, and the client said, well, listen, that's not me, but yet the defendant is saying, listen, I have all of these aliases that are coming up. The purpose of that deposition is, and don't take offense at it because this is what they're entitled to do, is to clarify who you are, what happened, because they may be getting information from another source that may be counteracting with your information, which gives them the illusion that you may have more than you're telling us. So they actually clean that up in a way.
That, but also remember, part of a deposition is the other side is sizing you up.
Right.
How is this person going to be on the stand? Can they answer a question? You know, we laugh about it in the office, but a lot of times before Effie's going to do a deposition, we get together and we say, okay, John Lewis, we're making up a name, it's not a real client. We say, how does he answer the question? Can he answer a question?
Can he answer
Answer the
questions
question.
straightforward? Are they credible?
Just think of it like this. When you're dealing with family members, there are family members you can ask a question, they get right to the point answer. Others, you have no idea what they're answering, and they babble on and on and on. It's the same with clients. You don't know how they're going to react to questions. How are they going to stand up? How will they testify for down the road? Because a lot of times, you know, when it's not a pop in their ear, it's a question of which side to believe, whether the plaintiff or the defendant, which driver to believe. They're going to say, well, this person seemed more credible.
You know, that's another issue also. You know, if I was, let's just assume I was a defense attorney and I was having a deposition with a plaintiff's attorney, hypothetically, you know, I would want to see that plaintiff very agitated. I would want to see him try to discredit him. So a lot of times the defense side will actually push hard to intentionally aggravate you, to get your motor started, because he knows at the end of the day, if you have a short fuse, he's going to prey on that. And at the trial, he's going to utilize that, because at trial, those jurors are going to look at that and say, you know what, this guy's got a short fuse. It's going to discredit him. So let me ask you a question. Let's assume, Effie, that you have a plaintiff that's got an attitude. What are you going to tell him prior to that deposition?
I mean, the best thing that you can do is just ask the client to stay calm and inform him of the consequences of potentially losing your temper. It's
Or to
the
take
best
a break.
thing.
Sometimes when you see your client,
Exactly.
you sometimes say, you know what, I think we need a few minute break. You know, I need to go to the restroom, or the client needs, you know, just.
Yeah, so it's imperative that you do not lose your cool, especially at these depositions, because the other side is looking to pick anything they can to discredit you. Tell the truth. Never fabricate. You know, I always tell people, they say, well, should I come in a cane or a neck brace? No, you don't. You come in as who you are, because your injuries are your injuries.
They've been watching too much TV.
You know, what happens is, and we're going to get into an area of investigation as well, because they say, well, are there investigators looking at you? Damn yippee, there's investigators watching you. If you have a case where you have neck surgery, all right, and there's questionable liability, or there's questionable damages, or there's questions regarding biomechanical issues, they're going to hire an investigator to come out, and they're going to watch you from down the block. And let me tell you, folks, I did that stuff. I was involved with it for many, many, many years. If you think you're smarter than that investigator, or you were smarter than me in getting you on film, never going to happen. All right, because I'm going to get you, or they're going to get you. So I always tell people, if you can do it, you do it. If you can't, you don't. You never fabricate it, because if you go to that deposition in that neck brace, in that walker, and you walk in there and they got film of you chopping down a tree at your neighbor's house 6 months earlier, you just killed your case. You do what you can do.
No, that, but
never
you're lying.
fabricate.
You're essentially lying.
Yeah,
You know,
those
another-
investigators will get you. They are trained to do this. They are trained very heavily, and you are not smarter than an investigator. I'll tell you that right now. So don't try to blow the wool over them. They will get you, and they'll get you on film.
Tom, an important point to realize about a deposition is that what we, the attorneys, say is not evidence, okay? That is not proof in any manner. The evidence and the proof that we need is through your voice. You were there, the client was there, and what they testified to. That is the evidence, and that is what they're going to use either for or against you. What we, the attorneys, say is not evidence at all, and not to be considered at all as evidence by the jury or in any manner. So there's a lot to go with the prep, but at the same time, they're evaluating the case as well. They're evaluating their client when we question them. They're also evaluating whether they should settle, fight this case. There's so much going on.
Yeah,
that
that deposition is
and
very
also,
important.
And Effie knows better than anyone, I would say. She's written a lot of motions. A lot of times, if we can't prove our case after deposition, or we can prove it, a lot of motions will come up for called summary judgment. We're saying the other side will do a motion for summary judgment for case to be dismissed, or we'll make a motion for summary judgment saying there is no issue as to how the accident occurred, called liability, which is a whole nother
Yeah, that's
show.
Let me just ask Effie another question. You have your client in the conference room now. You have the stenographer there who's putting everything down. You have the defense attorney. You're there. The client's there. Sometimes even the defendant is in that room. Correct?
Correct.
How do you control that? Because now you have a defendant who may be very aggravated that you as a plaintiff is going after him, and of course they don't understand it. They think you're going after their house, their dog, their cat. They think that you're going to go after them hook, line, and sinker. How do you control that situation?
The best thing is to understand that a deposition is a deposition. However, it doesn't have to be adversarial. You have to be professional, and that means be professional with the other side, with the defense attorneys, even with the defendant. You can say hello, good morning. It doesn't have to turn into a dogfight at all. Those are the worst kinds.
And in turning into a dogfight actually discredits your case.
Exactly, and it's just all around. You don't want to be unprofessional, and you just have to put on a smile.
I know you, and I've seen you do many depositions, and sometimes you get a little heated and you object to quite a few things.
Oh, I've learned to calm down on my objections.
But objecting is actually
sometimes it's strategic.
Supporting some of the questions that defense attorney may ask you that are now becoming irrelevant to the case, and you have to be sharp enough as an attorney to understand that so it doesn't get on the record, correct?
That is true, but even if I object and the answer still comes out, because you can only object to certain things during a deposition, it all comes out. The important thing to know is that will this deposition transcript, will the things in this transcript be able to be submitted to the jury if your case goes to trial? So you can say whatever you want during a deposition. It's not necessarily all going to be admitted into evidence.
We got a couple of minutes left, so I just want to explain one more thing about depositions, and correct me if I'm wrong. At the end of the deposition, you will have the opportunity, when that is transcribed, to make corrections to that deposition. You go through it on the back page. You can actually make corrections to anything that on it. You always have an opportunity to do that. So you're hitting this, and that means that there's an issue. Tell me why I'm wrong.
You're not wrong. You
so.
can make corrections. It's called an errata sheet. However, you want to be careful about the corrections that you actually make, because you have to state your reason for making the correction. So if you're making a statement that's a total opposite of what you originally stated, that all goes on the record, the reason for changing your earlier testimony. So you can make changes, but you don't want to make a change that's so...
It's not written in stone at that point, though. You can make the changes.
You can.
Minimal
you
changes
can.
at best.
Right, when you make a significant change,
you didn't get hit on the right side, you got hit on the left side, you can't do that. Or, you went to the hospital when you really didn't go to the hospital. I mean, these are changes you can't make. So, minor change you can make. Listen, we're running out of time here. Effie, thanks so much for being on the show.
Thank you.
Next week we have another exciting show coming up. We have so much to talk about, so much, regarding legal issues here in the state of New York and on Long Island. If you have any questions that you want to ask, you can always email us at mhtv.com. Send us your questions, and we'll be more than happy to talk about the topic. So until next week, I want to thank you all for watching. Thank you, Channel 20 Cablevision, for airing this program, and we'll see you next week on Legal Straight Talk. Have a wonderful day.
And what's best for you. What's best for you may not be what's best for another person. So overall, all I'd say is be careful out there. and make sure you hire an attorney that knows what they're doing, has experiences in the courts.
How important is it to be honest on your deposition?
It's extremely important, not only for the client, but also for the attorney. Attorneys are governed by the rule of ethics. You could potentially be disbarred if you're found to be untruthful. The profession is based on, it is based on honesty, and, just, I think generally just making sure that you keep to that. As for clients, it's also important because, you have to prove your case. You can't just say that you have a broken arm and not have a broken arm. You have to prove your case with, different evidence. That's, you have your medical records, you have your deposition, which is the client's testimony. But a lot of the times these proceedings are under oath, which means, you swear to tell the truth. And if you're not truthful, you could potentially perjure yourself, and that's not something that you want on your record. So honesty is a big, it's an important factor, and that applies to both your clients and attorneys as well.